This is Katherine Watt. I'm a Catholic American writer and paralegal, and I'm recording a presentation on Monday, February 23rd, 2026, about litigation that's going on in the Netherlands in a city called Leeuwarden. And this slide deck has, I think, 55 slides divided into 9 sections. I think that it will last an hour or an hour and a half. The camera is not on, so people can listen to it as just audio, or you can listen to it and watch the slides and read the slides as they're going on. It's basically a case orientation or a case document reading guide for people who want to read more about the case or want to just get a general idea of what the case is about. It's actually 2 cases, which I will talk about in the presentation. So this is the outline. It's going to start with an overview about the litigation, which is 2 cases, a little bit about my involvement in it, and a little bit about the limitations of this presentation. Then there's a second section about general information on civil law and tort law, because it's a tort, both of the cases are tort cases. Then I will do a summary of the disputes, procedural history, a summary of the plaintiff's version of the factual history and the legal arguments. In the section number 6 is about plaintiff's views of what is actually motivating the defendants. And then there's a section about how the defendants have responded in their own factual history and legal argument documents. Then there's a little bit about a hearing that is scheduled for Monday, March 9th, so 2 weeks from today. And then I will switch over from the PowerPoint slide deck to my website at Bailiwick News Archives on WordPress, where I have put a page and uploaded case documents so that readers who want to read the case documents for themselves can go there and look through them. As I said, there are 2 cases going on. The main case was filed in July 2023. It was written by 2 lawyers, Peter Stassen, who's still working on the case, and Arno van Kessel, who is not working on the case anymore. They initiated it by writing a summons and complaint on behalf of 7 plaintiffs. So 7 Dutch citizens who took 1 or more Pfizer vaccines. That group of 7 took the vaccines in 2021. One of those people has since died, but there are 6 left in the case. And the case was filed at the District Court of North Netherlands in the Leeuwarden Division. The second case was filed in March 2025, also by Arno van Kessel and Peter Stassen. And that one was not a complaint. It was a preliminary procedure called a request for provisional evidence proceedings. That one was filed on behalf of 3 petitioners who were also Dutch people who had taken vaccines. That one was also filed in the District Court of North Netherlands at Leeuwarden. Both cases rely on the same fact history and the same legal arguments. Both cases hinge on the truth or falsity of the information that was provided to the public, including the plaintiffs and the petitioners, by the defendants, which is the same group of defendants for both cases. And if the information was false or simulated, whether the defendants knew or should have known that they were presenting false information to the public, whether they had an obligation to verify or check the truth of the information that they were providing, and whether they had an obligation to only present true information to the public. The plaintiffs and the petitioners in both cases are seeking public evidentiary review and evaluation. They want the evidence to be put before a court. They want the court to test it and evaluate it and decide which evidence is true and which evidence is false, which evidence is misleading. That's the evaluation part. The defendants oppose public evidentiary review and evaluation, and that's one of the basic disputes going on between the two parties. I became involved in the cases in late January 2025 because attorneys for the plaintiffs and petitioners asked me to testify. In March 2025, when they filed the request for provisional evidence proceedings, I was listed as one of 5 nominated witnesses. And the same group was then nominated in the main case in a different filing that was submitted in June of 2025. The subject matter that I was asked to provide information about is the legal research I did mostly between 2022 and 2025 about US and international law governing communicable disease control, pandemic preparedness and response, and biological product manufacturing regulation. And that information is applicable to any judicial review that might happen of the things that the defendants did and did not do when they were presenting information to the public about coronavirus and about COVID vaccines. In September 2025, on behalf of the plaintiffs or to support their arguments, I finished writing a report called the St. Benedict Memo, which is about, again, my legal research and my findings. The bulk of that report, which is 280 pages, is a large section tracking the development of U.S. congressional acts between roughly 1938 and 2006, because that's sort of the main period of time in which the relevant laws were put into place. There are some limitations on this presentation. So again, at the end, I will give you information about how to find the case documents to look at it yourself. This is a presentation of facts about the litigation and the cases and my interpretation of the legal arguments that have been presented by the plaintiffs and by the defendants. There is overlap between my interpretations of the integrity of scientific and biomedical evidence that's available and my interpretations about how law applies to the facts and the interpretations of those things that are offered by the plaintiffs, by the defendants, and by other nominated witnesses. So on some of these things, I have reached the same conclusions as other people. There's also divergence along the spectrum. On some very minor things, I disagree with other interpretations, and on some things, I disagree quite sharply. A lot of fact information is not known because of the limits of scientific knowledge and because in this case and in many similar cases, important evidence has been withheld by the people who control it or redacted by the people who control it so that sections of it are missing or not available. Some information has been disclosed, but in distorted or misleading forms. And then, as I said, even two people looking at the same evidence, setting aside whether it's quality evidence or corrupted evidence, also can reach different legal conclusions about what it means. And that situation exists for this case. So the case documents themselves and some supporting documents like memos and affidavits and transcripts are available at that archives page. I recommend that if people want to read documents for themselves, you start with the July 2023 plaintiff's complaint, then read the January 2024 defendant's answer, the one that was submitted by the state of the Netherlands and the government employees who are sued in these cases, and then read the June 2025 plaintiff's conclusion of reply, which is kind of their their last um, addition to, I think it would be similar to an amended complaint here or a final reply in the United States. So just added information to what they had already said in July 2023. And now I'm going to talk briefly about civil law and tort law in general. So, some general information about civil law and tort law. What is civil law? What is a tort? Civil law has to do with legal action that's taken under law relating to the private rights of individuals and to legal actions involving these. It is distinct from criminal law. It's distinct from contract law. It's distinct from administrative law and other types of law. But some incidents can give rise to claims under more than one kind of law. The root word for civil law is civilis or civis, which is from the Latin word for city. A tort is a wrongful act, injury, or damage not involving a breach of contract for which a civil action can be brought. And I will talk a little bit later about why it's separate from breach of contract. Mostly it has to do with there is no specific written document existing between the two parties saying this is what party A has to do in exchange for which party B will provide usually money. And if one party or the other doesn't do it, then they have claims against each other. A tort is broader than that because there may or may not be a contract between them, and usually there isn't. The tortfeasor, Tortfeasor, is a person or entity that commits a tort, which is a civil wrong that causes harm to another party. And the root word for tort and tortfeasor is the Latin word tortus, which means to twist. The same root words are for the word torture, the inflicting of severe pain, any method by which such pain is inflicted, a cause of such pain or agony. What is a cause of action? So, a cause of action is a set of facts and legal arguments that give an individual or entity the right to seek a legal remedy against another individual or entity. Another way of saying that is a condition under which one party would be entitled to sue another. And another way to say that is a set of facts that, if true, entitle an individual or entity to be awarded a remedy by a court of law. A cause of action can come from an act or from a failure to act, meaning somebody who was supposed to do something and didn't do it. They omitted to do it. It can be from a breach of duty or a violation of rights. Incidents or events can create a cause of action that supports the filing of a civil lawsuit seeking remedy for wrongs like property damages. So if you drive your car into somebody's fence and then their fence is broken, they can sue you because you caused property damage. It can be about personal injury. So if somebody drives their car into you and you get injured, then you can sue them for injuring you. And for monetary loss. So if somebody does something that causes you to lose money, then you can sue them for that. Incidents or events that create a cause of action for a civil case can also sometimes support criminal prosecution. So in a thing like a car accident, if the person who was driving did it on purpose, for example, then it would also the basic facts are a person was driving a car, hit another person, injured the second person. That could be the basis for a criminal prosecution or for a civil case. In the context of coronavirus and COVID events, there has not been any will to prosecute the actions of people fulfilling roles like the ones played by defendants in the Netherlands cases for criminal acts, even though there is evidence to support those kinds of prosecutions. There are four elements to a tort claim. Number one is that the defendants have to owe a duty of care to the plaintiffs, meaning there has to be some relationship between them that the plaintiffs had a right to expect that defendants would do or not do things for the protection of the plaintiffs. The second thing is there needs to be a breach of the duty of care, some sort of failure to fulfill the duty or obligation, and that could be by acts or by omissions or both. There needs to be damage that resulted from the breach of duty of care, and there needs to be a demonstration of causation. So, some sort of way of connecting the breach of the duty of care to the injury suffered by the plaintiffs. Who can file a civil tort action? One or more plaintiffs can file a civil tort action or lawsuit against one or more defendants. And to receive compensation by court order, the plaintiffs have to allege, meaning they have to claim, and then they have to prove with evidence those four elements of the tort claim: that defendant owed plaintiff a duty of care, that the defendant breached the owed duty of care, that the plaintiff suffered injury or harm, and that defendant's breach of the owed duty of care caused plaintiff's injuries. What is a duty of care? A duty of care is a legal requirement for individuals and organizations to adhere to a standard of care while performing acts that could foreseeably harm others. The duty generally comes from an individual's actions or from his relationship to another person or from a specific situation. So, an example is that grocery store owners and the managers who work for them owe a duty of care to customers to maintain safe walking surfaces. And this is where slip and fall cases come from, this type of situation. If a surface is wet because somebody was mopping it or something spilled, the manager is obligated to act to let customers know that they should walk more carefully or they should go around that wet spot. And they can do that by putting up a sign or by having a person stand there and say, go around, this spot is not safe to walk on. And if they don't do that, then they might be vulnerable to a lawsuit if somebody doesn't see the wet spot, slips on it, falls, and gets hurt. And the next section, we're going to talk about a summary of the dispute in the cases that are going on in the Netherlands. The third part of this presentation is a summary of the dispute between the two parties, the plaintiffs and the petitioners on one side, and the defendants, who are mostly government officials, on the other side. The dispute boils down to reciprocal allegations of fictional or unsubstantiated perceptions of reality. The defendants take the position that the government has a duty of care to protect population from physical threats, and that the defendants in these cases fulfilled that duty of care by implementing measures, including vaccines, with protective effects. Defendants take the position that coronavirus presented a severe physical threat and it was a public health emergency. The defendant's position is that the government has no duty to verify claims about the danger that may be posed by an alleged physical threat. and they have no duty to verify claims that may be made about the effects of alleged protective measures, such as vaccines. The defendants take the position that the government has the authority to classify challenges to its claims. So, challenges to the things that the government says about threats and about countermeasures. The government has the authority to classify those challenges as misinformation or disinformation and then censor or suppress those challenges, and also to use informational and psychological tactics to obtain compliance with whatever the emergency response measures are that the government has decided to apply. The defendants have taken the position that the government has a duty of care to protect the population from things like misinformation or informational or psychological threats, and that the defendants in this case fulfilled that duty by censoring and suppressing counterclaims about coronavirus and counterclaims about COVID vaccines. The defendants have taken the position that the government has no duty of care to refrain from participating in misinformation campaigns itself. So the government is not obligated to not participate in lying, in deceptions, in simulations about threats and emergencies, in providing false information, in fabricating evidence. Put a different way, the government is, in the defendant's view, entitled to participate in presentation of false information to the public. And I think of this, or have tried to use the phrase cognitive harm to distinguish it from physical harm. Physical injury, physical harm is when your body is damaged. Cognitive harm is harm or damage to your ability as a human being to gain knowledge or understanding of a situation in which you find yourself. The plaintiff's position, obviously, because it's a dispute, they take the opposite positions. They say the government has a duty of care to protect population, the people of the country, from informational and psychological threats, lies, and also from physical threats. In this case, from the vaccines, which were camouflaged using lies as protective measures against a falsified physical threat. The plaintiffs take the position that the government could have and should have fulfilled that duty by verifying claims about alleged physical threats so that they could protect the population from lies, from cognitive harm, and so they could protect the population from physical injuries that had been facilitated through the lies. So physical harm, two parts, cognitive harm, physical harm. The plaintiff's position is that the government breached that duty by failing to verify claims about the alleged physical threat posed by coronavirus, and also by failing to verify claims about the alleged protective effect of vaccines. And plaintiffs also take the position that the government breached its duty of care by directly participating in the distribution of false, fabricated, and misleading information. So this slide, we're now at slide 16, is about the defendant's acts and omissions that began in early 2020 and are still ongoing. Defendants stated at the beginning and still maintain this position that a physical threat, a novel transmissible coronavirus, existed, that it presented a severe or deadly risk of harm, and that it had been physically demonstrated to present a high risk of severe physical harm and death. The defendants stated that the countermeasures, vaccines, but also the non-pharmaceutical interventions, things like masking, things like distancing, things like business closure, stay-at-home orders, The defendants told people through their public statements that that was physically necessary and that it would be effective for countering the threat. And they told people that it had been demonstrated to be necessary and effective. And the defendants did actually characterize contradictory evidence as misinformation and disinformation. And they did actually suppress and censor and omit presentation of it. So the plaintiffs, in their initial complaint in 2023, and then in their final conclusion of reply in 2025, basically argued the defendants lied. And the plaintiffs phrased that as COVID-19 is not a disease, but a project. I'll talk a little bit more about that later. The plaintiffs argued that the physical threat from coronavirus was not real, it was not novel, and or it was not severe or deadly. They argued that the cognitive threat, the risk of informational and psychological harm, was real, is real, and it is severe and it is deadly. The plaintiffs argued that defendants fabricated physical evidence of the coronavirus threat and of the countermeasures' effectiveness by creating and presenting invalid false records, which can also be thought of as forgeries or simulations or theatrical props. Plaintiffs alleged or claimed or argued that defendants' acts and omissions inflicted on the plaintiffs intense fear and social discord. And in the United States, if people were to bring similar complaints to the one that the Dutch plaintiffs have brought, it would fall under the tort of intentional infliction of emotional distress or negligent infliction of emotional distress. Plaintiffs also argued that defendants' acts and omissions, which created the fear and created the emotional distress, led the plaintiffs to take vaccines, and then the vaccination caused injuries. And in the United States, if a similar case were to be brought, that would probably be the tort of battery or battery by proxy, because the government officials themselves, like the Minister of Health or the committee members on the advisory committees, didn't personally administer vaccines to the plaintiffs. They had it done for them by nurses and pharmacists and whoever else was administering vaccines in the Netherlands. Plaintiffs argue that physical countermeasures were not physically necessary and they were not physically effective for countering the threat. They argued that the physical countermeasures were unnecessary, ineffective, and unsafe, among other things, because there was zero benefit that had to be weighed against the incalculable risk of harm. So the petition that the plaintiffs have submitted to the court is asking the court to subject the evidence to adversarial cross-examination, to declare defendants' acts unlawful, and to order the defendants to compensate plaintiffs for the damages that the plaintiffs sustained. The defendants then filed their answers in 2024. They did a whole first round and then they did a second round, their final responses in 2025. And they adhered to the original script. They said the physical threat of coronavirus is real, it's transmissible, and it's severe or deadly. The defendants claim that they created and presented true, valid records containing verified physical evidence for the pathogenicity or disease causative ability of the threat, and that they presented valid records for the need for and effectiveness of the countermeasures and vaccines. So the defendants argue that they fulfilled their duty of care. And their petition to the court is, do not subject the evidence to adversarial cross-examination, declare that defendants' acts were lawful, and dismiss plaintiffs' tort claims, dismiss the case. And they also would like the plaintiffs to be ordered to pay the court costs. And here is where the legal research that I did between 2022 and 2025 comes in, because what I found and what I reported in the St. Benedict memo that I submitted for these cases is that there is no legal requirement for validation of materials and methods that are allegedly used to physically demonstrate the existence or the transmissibility or the severity in form and function of physical threats, such as claims about a biological agent being able to cause disease, or being the sole cause of disease, or being transmissible from one organism or person to another, or being capable of causing by itself, like in a sole cause way, severe illness or death. There is also no legal requirement for validation of materials and methods that are allegedly used to physically demonstrate the necessity and effectiveness, so again, form and function, of alleged countermeasures, vaccines. So in the communicable disease arena and the pandemic preparedness and response arena and in biological product law, the laws enabled and facilitated defendants' deceptive acts and omissions. They were never required to present validated physical evidence. They were never required to submit evidence to evidentiary review. There were no evidentiary standards applicable to anything that they did or said, and they didn't present valid physical evidence. They didn't submit it to review. They failed to present valid evidence to the public, and they did present invalid, unverified evidence to the public. But those things were not unlawful because they didn't breach or violate a standard that was not applicable to them and didn't exist anyway. The next section is a short procedural history. So the procedural history for the main case, um, which is still in Leeuwarden District Court, is that the 7 plaintiffs filed their initial complaint in July 2023, along with 90 exhibits, exhibits 1 through 90. And the case number is C17/190788, 23/172. Between January and February, all of the defendants except Bill Gates filed answers. In February 2024, Bill Gates challenged the Dutch court's jurisdiction, and in October 2024, the court issued an order saying Bill Gates is subject to Dutch jurisdiction. So then in November of 2024, Bill Gates filed his answer. In December 2024, the plaintiffs filed an increase of claim and request for pretrial hearing. I'll talk a little bit about those in a minute. In June 2025, plaintiffs filed their conclusion of reply, which, as I said earlier, was a sort of, I think, in the United States, that would be considered an amended complaint or uh, a final reply document, sort of adding to the original arguments. So they filed that, and they filed additional exhibits, 91 through 146. Between June and September 2025, the defendants filed their final answers. And in November 2025, the court granted the increase of claim, but denied the request for a pretrial hearing. So in December 2025, the plaintiffs submitted a letter. And along with the letter, they submitted expert reports that some of the nominated witnesses had prepared and video statements by all 5 of the nominated witnesses. The procedural history for the second case, this one is now at the Amsterdam Court of Appeal. It started in March 2025 when three petitioners filed a request for provisional evidence proceedings in the District Court of North Netherlands at Leeuwarden, case number C17/199273, 25/17. Not a complaint. Yes, this one was a preliminary procedure asking the court to hold a public hearing at which evidence could be presented, testimony could be taken, witnesses could be cross-examined, so that the petitioners could decide based on the results of that adversarial public proceeding whether they want to file a complaint, and if so, what kind of complaint. From June to July 2025, the defendants filed opposition. So they said, no, we don't want to have provisional evidence proceedings. In July 2025, there was a hearing about the dispute, whether there should or should not be public review of evidence through a court hearing. And in August 2025, the court decided and denied the petitioner's request. It said, no, we're not going to have an evidentiary hearing. In September 2025, the petitioners appealed that order to the Court of Appeal at Arnhem, Leeuwarden. There were conflicts of interest, so the appeal was transferred to the Court of Appeal at Amsterdam, where it is now, case number D100816. And then in December of 2025, at the same time that the plaintiffs in the other case, the main case, submitted expert reports and video statements, the three petitioners in the second case also submitted the same expert reports and the same video statements. Now we're moving up to January 2026. The defendants filed their opposition to appeal, asking the Amsterdam court to refuse to hear the appeal. And in January 2026, at the end of the month, the Amsterdam Court of Appeal scheduled an oral hearing to be held March 9th, 2026. And the subject matter for that hearing, which is coming in 2 weeks, will be reviewing the arguments for and against allowing the appeal to be heard at all. It is not a hearing on the merits. It's not a hearing about the substance of the evidence. It's a hearing about whether the appeal is allowed at all. And I'll explain that. I forget which section, but it's, I think, section 8 after this. Now we're at slide 23. This is the fifth part, and it's a description of plaintiffs' factual history and legal arguments. This is a presentation section that's about the factual history and legal arguments that were presented by the plaintiffs in the main case. That's the case that had 7 plaintiffs originally and now has 6 because one of them died. These people are people who live in the Netherlands. They're members of Dutch society. They, at the time in 2020 and since then, read Dutch print and digital newspapers. They watched and listened to broadcast and digital video and audio media coverage. They watched government officials deliver public statements about coronavirus disease and vaccines. And they developed intense fear about the threat of COVID infection, about severe disease and death for themselves and their loved ones. So, because they were frightened and because they believed what the public officials had said and what the media personalities had said about the disease and about the vaccines, they complied with vaccination advice. Each of them received 1 or more Pfizer vaccines in 2021. Earlier in the case, the defendants, part of their answer was, we don't believe that the plaintiffs even got vaccines. And so the plaintiffs did submit their vaccination records in one of the later rounds of documents. All of the plaintiffs sustained psychological damage. Um, Sometimes that's called immaterial damage. Sometimes it's called mental harm in the form of mostly fear and social discord, like a sense of their society being full of conflict because people were fighting about what was going on and what should be done. And some of them sustained physical injuries from the vaccinations, or that they allege were caused by the vaccinations. So they put in their original complaint in July 2023 their petition for remedies. So what they were asking the court to do. They asked the court to declare that defendants as a group and individually have acted unlawfully toward plaintiffs by intentionally misleading them in an unlawful manner and thereby inducing them to get COVID-19 injections the defendants knew or at least should have known were not safe and effective. In the United States, that request would be called a request for declarative judgment because they're asking the court to declare something, declare that the defendants acted unlawfully. And then the second thing they asked for was that the court order the defendants to compensate the plaintiffs for their damages, including court costs. Then the plaintiffs amended their petition for remedies when they filed an increase of claim request in December 2024. And then they repeated that same request in June 2025, and the court granted it in November 2025. The amended remedy list requested by the plaintiffs was that the court declare that the defendants, as a group and individually, have continued to act unlawfully towards the plaintiffs up to the date of the final judgment rendered by the court in this case, including an unlawful omission, by deliberately and unlawfully misleading them and the Dutch people in order to induce the plaintiffs and or the Dutch people to undergo COVID-19 injections, of which the defendants knew or at least should have known that these injections were not safe and effective, or at least that the false and misleading narrative propagated by the defendants in the context of the project COVID-19, the Great Reset, and or the COVID-19 injections introduced in the context of this project were harmful to the health, fertility, and psychological well-being of the defendants and or the Dutch people. And the plaintiffs asked the court to order the defendants to compensate the plaintiffs for their damages, including court costs. So the difference, the change between the July 2023 request and the request that was granted in November 2025 is that the plaintiffs filed their case and then watched as the defendants continued to say the same things in the same public platforms, media platforms, public statements. And so they amended the request to say that if the case concludes with the court finding that the defendants acted unlawfully, it will not just apply to the unlawful acts they committed early on in 2020 and 2021 that led to the vaccinations. It will include all of the unlawful acts and unlawful omissions that the defendants have committed in 2020 and 2021, and then continued since then up into the present. The defendants are divided by the plaintiffs into 5 categories. The first category is government officials. Some of those are elected, some of those are appointed. Then there is one semi-government official, which I think we would call a contractor here in the United States. Then there's one pharmaceutical industry defendant, that's Albert Bourla, representing Pfizer, which I guess would also be a contractor. Then there are 2 non-government officials, and then there are 2 media defendants. So there are 17 defendants. They're depicted in this diagram that I made And there's a version that's larger that you can read the captions that will be available at, or already is available at my WordPress page. 16 of the defendants are natural persons, so human beings, and one of them is a government entity. So that's the state of the Netherlands. These roles had other actors in other countries playing corresponding roles, using the same scripts, but saying the lines in the local language in each country. For example, this person up here is the Prime Minister of the Netherlands at the time. He's now the Secretary General of NATO. At the time, he was the Dutch Prime Minister. His name is Mark Rutte. The corresponding figure in the United States government would be Donald Trump, who was president at in 2020, and Joe Biden, who was president in 2021 and thereafter. Here, there are two men who were serving as Minister of Health, Welfare, and Sport, which is what the Dutch version of the Department of Health and Human Services is called. This one is a man named Hugo de Jong, and this one is a man named Ernst Kuipers. The corresponding figures in the United States would be Alex Azar, who was the HHS secretary in 2020, and Javier Becerra, who was the HHS secretary after Alex Azar. Bill Gates and Albert Bourla would be the same. They would occupy the same function. Bourla as a pharmaceutical industry defendant and Bill Gates as a non-government defendant because they played the same role in the cast in every country because they work outside of the national, they're supranational organizations or multinational corporations. This defendant, her name is Agnes Kant, and she worked for a private contractor with a contract with the government to provide pharmacovigilance, so monitoring of adverse effect reports from the use of drugs and vaccines. In the United States, it would be the people who are responsible for the vaccine adverse effects reporting system, VAERS, and the other things like vSafe. And I'll just point out a couple more things. These two are the media defendants. There could be many media defendants in the United States. And this group is what's called the Outbreak Management Team, the OMT in the Netherlands. And the corresponding organization or committee in the United States was the White House Coronavirus Task Force. There were actually three versions of that. One was under Trump, one was under the Biden administration transition team, and then the third one was under the Biden administration after the transition. So the people in the United States that would be in this section would be people like Anthony Fauci, Francis Collins, Rochelle Walensky, Deborah Birx. That's just the section of the organizational chart that they would fill. Plaintiffs filed their initial complaint in 2023 and their conclusion of reply in 2025. They said that defendants owed a duty of care as government officers and contractors and advisors and journalists to the plaintiffs. The defendants owed the duty to refrain from providing false, fabricated, and misleading information to the public about the existence and severity of coronavirus threats and the composition and probable harmful effects of COVID vaccines. They said the defendants owed the duty to provide true and complete information about coronavirus and COVID vaccines. And they argued that defendants owed the duty to refrain from omitting, withholding, concealing, excluding, suppressing presentation of true information from sources documenting that the information provided by the government and by the advisors was false or was fabricated or was misleading. Plaintiffs argued that there were several breaches of this duty of care. They said the defendants, as individuals and also as members of the group, breached the duty owed to plaintiffs by knowingly committing acts presenting false and fabricated and misleading information to the public. They projected or instilled a false preferential reality or preferred reality. I'll talk about that more later on. They breached it by knowingly omitting and concealing true information, and they knew or should have known that what they presented was false and fabricated and misleading. The plaintiffs also said that defendants knew or should have known that the plaintiffs would rely on the credibility of the defendants and the information that the defendants presented to make personal decisions about what they should do. So the defendants should have known that the plaintiffs would believe them and would isolate themselves, would keep distance from other people, would wear masks, would undergo testing, would participate in contact tracing, and would get vaccinated. The plaintiffs argue that the defendants foresaw or should have foreseen that their actions created a risk of harm to the plaintiffs, including severe psychological and social distress from believing that Dutch society and the plaintiffs and their loved ones were under a dangerous threat, and also the physical injuries, the biological malfunctions attributable to vaccination. This is basically uh, the form in which the plaintiffs conveyed what I think meets the standards for psychological, behavioral, and physical, biological, medical experimentation, torture, mutilation, and homicide. And those are things that are war crimes. But again, those are not being prosecuted by the prosecutors who could bring war crimes charges. For the damages section, remember I said there's the four factors or elements of a tort claim. You have to show there was a duty of care was owed, there was a breach of the duty of care, the plaintiff suffered an injury, and the injury was causally related to the breach. So this is the part about the damages or the injuries. The plaintiff said that all of them were placed into a false preferential reality through the defendant's acts, which was lying, and omissions, which was concealing. All of the plaintiffs adopted false beliefs about the existence and severity of the coronavirus threat and about the necessity, composition, and probable effects of COVID vaccines. All of the plaintiffs suffered severe psychological and social distress from falsely believing themselves and Dutch society to be under dangerous threat. All of the plaintiffs were vaccinated one or more times. Some of the plaintiffs sustained major and minor physical injuries attributable to vaccination. One of them has died. And all of the plaintiffs sustained psychological harm from not knowing whether or when they might in the future develop major physical injuries attributable to vaccination. For causation, the plaintiffs said, but for the acts and omissions, mostly the oral and written statements of defendants who owed a duty of care and breached it, the plaintiffs would not have believed that coronavirus presented risks of severe disease and death for themselves, their loved ones, and Dutch society. But for, so if they hadn't believed defendants' false information about coronavirus, plaintiffs would not have suffered severe fear, psychological, and social distress. But for believing false information, the plaintiffs would not have believed vaccination to be necessary at all and would not have taken vaccines. And but for taking the vaccines, plaintiffs would not have sustained physical injuries or died from vaccine damage and would not suffer from intense fear that they may, in the future, develop physical injuries attributable to vaccination or die from vaccine damage. The plaintiffs, in their two main filings that I mentioned, the July 2023 complaint and the June 2025 conclusion of reply, presented evidence specific to each defendant and also evidence applicable to all of the defendants as a group, taken as a group. The evidence specific to each defendant included written records that were reviewed or prepared or signed by the defendants, things like government reports, things like infection and death dashboards, letters, emails, academic papers, news reports, corporate reports, regulatory documents. And the other main category of evidence specific to each defendant was video and audio records of public statements that had been delivered by the defendants. The plaintiffs argued that these government, corporate, and media records and public statements contained false, fabricated, and misleading information. Another category of evidence that the plaintiffs submitted was critical analysis by other sources, non-government sources, non-corporate authors, some of which cited data that had been reported by government and corporate sources, and some of which cited data obtained by non-government, non-corporate researchers. The plaintiffs argued that these independent sources presented true information, which the defendants concealed or suppressed, and that if it had been presented by defendants, then the plaintiffs would not have sustained the mental and physical injuries, fear, social discord, vaccine injury that they did actually sustain. One of those key documents is what's known as the Pfizer-BioNTech cumulative analysis. That was the full name of it is the Cumulative Analysis of Post-Authorization Adverse Event Reports, which compiled and analyzed about 42,000 case report records of diseases and disorders and deaths that had occurred shortly after vaccinations that were administered between December 1st, 2020 and February 28th, 2021. This document was received by the US FDA Center for Biologics Evaluation and Research, or CBER, date stamped April 30th, 2021. It did not become public until litigation under the Freedom of Information Act. I think it didn't come out until November 2021 or maybe November 2022. I can't remember. But the plaintiffs argued that that report provided causation evidence or evidence that the diseases and disorders and deaths that occurred after vaccination were causally attributable to vaccination itself, which demonstrated that the vaccines were unsafe and ineffective. And plaintiffs attributed knowledge of the report to the defendants and willful concealment of the report and its implications from the public, which would basically show an intent to deceive. The defendants take a very different view of what that report means, and I'll talk about that a bit later. The next section, section 6, is about plaintiffs' views of what defendants' actual goals and motives were and are. I took a little break from recording and I looked up when the Pfizer cumulative analysis was released to the public, and it was in November of 2021. through a FOIA. Prior to that, the FDA had it, and the plaintiffs argued that other regulatory agencies and government officials in other countries had it, uh, at least by April 30th, 2021, but they did not disclose it to the public. Um, it came out to the public through the FOIA in November 2021. So moving on, the plaintiffs realized that because of what they were alleging the defendants had done and had failed to do, that it would be useful to provide an account of what the defendants' true goals and motives were to explain the behaviors. And I put together an organizational chart, which is in the reading guide that goes along with this presentation video, that provides a heading section above where the 17 named defendants in the Dutch cases are located. And in that header section, it depicts the role played by the European Union, NATO, the World Economic Forum, the United Nations, the World Health Organization, and their member states, funders, executives, affiliates, which can be understood as tortfeasor entities and individuals external to the Dutch government and the Dutch media. So the government is sort of this section. This is the media. This is the non-governmental, supranational, multinational corporate defendants. Um, but the people who worked at the EU and NATO and the World Economic Forum and the UN and who are not in the Dutch government themselves. So to unpack that a little bit more, the defendants present a worldview that they believe justifies the coordinated, responsive action that they took. Defendants might sincerely hold these beliefs, or they might just pretend to hold them because pretending to hold them gives them the justification to do what they did and to omit to do what they omitted to do. And I want to point out that for all of these things, what the worldview is describing are complex, dynamic systems, natural systems, living systems, for which verified physical evidence and attribution of causation aren't feasible and aren't usually presented anyway, because they're too complex and they're too dynamic. There are too many feedback loops. It's all happening in time, not in like a static situation. This is why they use models instead of actual sampled, isolated, experimental evidence. So the worldview presented by the defendants to justify what they do and what they don't do is that there is a physical carrying capacity for the earth, for human beings, that it's known and that it's already exceeded. And that as a result of that, there are food supply shortages, there are social conflicts and wars, there are energy supply shortages, there's pollution, there's climate destabilization in the atmosphere and in the ocean and on land. Ecosystems are destabilized. There is vulnerability to global pandemics, and economies are destabilized. And they ascribe the cause of those threats to there being too many people, like numerically too many people, people who are living too long with too much health and too many years of life and using too much land and food and water and fuel for the activity that humans do. So the solutions that have been planned and have been implemented are to prevent new births, to weaken health, and to shorten lifespans so as to use less land and food and water and fuel. This is an excerpt from the judge's order. It's dated October 16th, 2024. Now, it's an order in the main case where the judge decided or ruled that Bill Gates is subject to Dutch jurisdiction. And I'm putting it in here because it's a very good summary of what plaintiff's basic argument is. So I'm just going to read it. The plaintiffs have based their claims, briefly and factually stated, on the following. Hofstra et al., named the defendants, have implemented the COVID-19 The Great Reset Project. This is a project aimed at the total reorganization of societies in all countries that are members of the United Nations. As described by Klaus Schwab in his book COVID-19 The Great Reset. In this reorganization, all factors that determine human life are made the subject of forced change by the World Economic Forum and the UN. Characteristic of this political ideology is that this forced and planned change is presented as justified by pretending that the world is suffering from major crises that can only be solved by centralized, hard global intervention. One of these pretended major crises concerns the COVID-19 pandemic. The defendants have individually and as a group acted unlawfully toward the plaintiffs by misleading them in the context of the implementation of the COVID-19 The Great Reset Project into having COVID-19 injections administered, which the defendants knew, or at least should have known, that these injections were not safe and effective. These COVID-19 injections were never intended to protect plaintiffs from a venomous virus. Plaintiffs suffered mental and physical injuries as a result of these injections, according to the plaintiffs. So again, the judge in this order is not saying, I agree with how plaintiffs have presented their case. He's just, or she, the judge is just summarizing, this is what the plaintiffs are arguing. And I want to add one note that the judge did not get into this summary. The plaintiffs also alleged that they have sustained mental injuries as a result of being subjected to defendants' deceptions, in addition to the mental and physical injuries they suffered as a result of vaccinations. It's a two-part thing. It's the cognitive harm and it's the physical harm. And unpacking this a little bit more, this is a part where it's somewhat my interpretation of information that I have learned and somewhat my interpretation of what the plaintiffs were trying to get across in their complaint in July 2023 and their final filing in June 2025, which is that pretextual or simulations of cross-border crises drive proxy action. It's a method for transferring government legitimacy without letting people know from the national government to the supranational institutions. The supranational institutions, like the World Economic Forum, like the UN, do not have legitimate authority to directly govern human societies, like populated countries or the populations of countries. They're not hereditary monarchies. They're not elective or representative or parliamentary states. Organizations like the UN and NATO are formed by treaty ratification by legitimate national governments for the claimed purpose of coordinating international cooperation. And private organizations like the World Economic Forum are formed by incorporation as non-governmental private organizations, allegedly for the same purpose, to coordinate and advise on international cooperation. Because they don't have any direct authority, they execute their projects through the acts and omissions of government officers in each member country. So there's a bunch of different ways that they do it. They have financial control of public information channels, like publishing houses, broadcasters, newspapers, universities, schools, think tanks. They foster the national government officials developing the belief that there are or could be severe cross-border crises, which would make it necessary for prescribed responses to be carried out. Or they help those national government officials develop an indifference to whether it's true or false that alleged cross-border crises are occurring or could occur. And they have a bunch of different names for this. They call it the Great Reset. They say Build Back Better, New World Order, Sustainable Development Goals, Fourth Industrial Revolution. They change the names from time to time. But the goal is to centralize power for the supranational non-governments by orchestrating the illusion of these emergencies that are perceived as too large or too fast or too threatening to be managed by national or state or local governments, or to be managed just by families and civic or religious organizations at the local level. They foster the public and the government belief that children are a threat to society and that birth reduction through birth control or population control is necessary. They turn national governments from thinking that their duty of care is service to families and workers and communities toward service to the supranational organizations themselves. So they promote contraception and other methods of reducing population, reducing movement, reducing travel through the national governments, through proxies. They do it sometimes through overt methods, like increasing the levels of debt that families and businesses and governments are under, which is an impediment to marriage and family formation. They do it by promoting divorce and contraception and abortion. And they characterize those things as acts of personal liberty or acts that are done for the societal good. But those sets of lies have not been enough to meet the goals that the members of these supranational organizations have. So they also use covert methods, such as falsified communicable disease and pandemic threats, with the policies that go along with that: isolation, movement restrictions, vaccination, which is poisoning, and sterilization characterized or masked as disease control. So those are bigger and faster lies. The plaintiffs provided evidence of the preferred reality being imposed on them by defendants. They mentioned UN Agenda 21, which was written in 1992. They mentioned UN Agenda 2030 and the Sustainable Development Goals, or SDGs, that was published in 2015. And they quoted from a video interview with a Marine general, a Dutch Marine general named Frank van Kappen. And the interview occurred on April 15th, 2018. And the general told the interviewer, "We are in the middle of a period in which we are dealing with an information operation, an information war. Yes, that's what it's called today. It's an activity of strategic importance, which is the manipulation of facts and events so that you present a preferred reality to your own population, to your opponent, and to the international public. We are in the middle of that. And that's where the plaintiffs got the expression, the preferred reality, that they use throughout both their original complaint and other documents that they've filed in these cases. In support of that, that they pointed out that Van Kappen had summarized what it was, they also provided documents from the Gates Foundation and Gavi and the World Health Organization about funding priorities, about vaccine supply, about increasing vaccine readiness or willingness, about pandemic preparedness. They provided information from the World Economic Forum annual meeting materials for the annual meeting that happens at Davos, conference announcements, agendas, reports, web pages. They provided a copy of the book written in 2020 or published in 2020 by Klaus Schwab and Thierry Malloret called COVID-19, The Great Reset. And they provided, I think they mentioned that Bill Gates wrote a book in 2022 or published a book called How to Prevent the Next Pandemic. If they didn't mention it, that's something I found when I was looking into his biography. They also put together a list of NATO documents, including Allied Joint Publication 3.10.1, which is the Allied Joint Doctrine for Psychological Operations. There's another one for information operations. There's another one for strategic communications, and there's another one for civil and civil military cooperation. And they put in a chart from one of those reports, or I guess it's a, yeah, it's a report or a plan showing the relationship between the Combined Joint Psychological Operations Task Force of NATO, which is up here, and its different divisions, including one called the Media Directorate, which is supposed to maintain relationships with radio, television, internet, print, and other media, so as to project this preferred reality through the media that the public reads or watches or listens to, which is exactly what happened to the plaintiffs in the Dutch cases. The next part we're going to look at is how defendants describe the factual history and the legal arguments. So I'm at section 7, which is slide 44 out of the set. This section is about the way that the defendants presented the factual history and legal arguments. The defendants filed their initial answers in 2024, most of them in January and February that year, except for Bill Gates, who filed his in November of 2024. And then they all filed, or all but one, filed final answers in summer 2025, between, say, June and September. Summarizing what they argued, the defendants argued that the plaintiff's core claim, which was that the defendants knowingly projected false, unsubstantiated, preferred reality onto the Dutch population, including the plaintiffs, with intent to deceive the people who heard and saw what they said, and with the intent to manipulate the behavior of people who read and heard and saw the information, was itself false and unsubstantiated. It was illusory, it was absurd, it was far-fetched, it was a conspiracy theory, and the plaintiffs were deluded into thinking that defendants had done such a thing as project a preferred reality. The defendants claimed that the coronavirus presented a true and severe physical threat, such that they had a duty of care to provide information to the public and to organize disease control programs and purchase and distribute products, including vaccines, and that they fulfilled their duty of care properly. So the defendant said there was no breach of the duty of care and they did not commit any unlawful acts or omissions. The defendants also denied that they presented false or fabricated or misleading information. So again, they said there was no breach of duty of care, there were no unlawful acts or omissions. All of the defendants, including the media defendants, argued that they were entitled to rely without verification on the presumed validity of information that they received from other entities, such as the Chinese government, the World Health Organization, the Imperial College, Pfizer and BioNTech, the US FDA, the EU, European Medicines Agency, the Health Council of the Netherlands, and other Dutch health authorities and other official sources. So, unpacking that just a little bit, most of the defendants were in the government themselves. They argued they could rely without verification on information that came into the Dutch government from other sources and also information generated by Dutch official agencies like the health ministry and the outbreak management team. The media defendants argued that they could rely on all of those same official sources also, and also had no duty to verify the information that they were receiving. The defendants denied that they had an obligation to present information exposing or contradicting as false the information that they were presenting. So, on both of these counts, they said there was no breach of duty of care, there were no unlawful acts, there were no unlawful omissions. Defendants also denied or disputed that plaintiffs had taken vaccines at all. They said there were no damages. Defendants denied or disputed that plaintiffs had sustained injuries, even if they did take vaccines. So, again, that was challenging that there were any damages to be compensated. Defendants denied that even if plaintiffs did take vaccines and they had injuries, defendants denied the injuries were caused by vaccination, which is a way of challenging or saying that there was no evidence of causation. Defendants characterized the April 2021 Pfizer-BioNTech report as, at most, evidence of a correlation of diseases and disorders and deaths with vaccination, but not evidence of causation. And they also denied that it represented a signal that should have required additional analysis or suspension of product use. Plaintiffs also denied, although I don't think I have it on this slide, that their acts, the acts of the defendants, were the cause of plaintiffs deciding to take vaccines. Defendants denied that plaintiffs had proved defendants even knew about the Pfizer-BioNTech report and its contents, or they denied that defendants had knowledge of it. In support of their own version of events and arguments, the defendants cited government reports and advisories that they had produced themselves. For example, the infection and death dashboards, advisory bulletins put out by the outbreak management team, recommendations put out by the Health Council. They cited reports and advisories produced by co-executors of the DECEAT project, for example, the EU, European Medicines Agency, the United States, FDA, CDC, NIH, China, the UK, Germany, World Health Organization, declarations on subjects like virology, epidemiology, product marketing, and use authorizations. The defendants cited academic papers they had produced or that they had funded other researchers to produce, which were published in journals funded by the defendants and the co-executors of the project. And defendants argued that the information in the reports and advisories and papers was true and complete. Moving on to Section 8, which is a little bit of information about the March 9th, 2026 hearing. As I said at the beginning, both of these cases hinge on the truth or falsity of the information that was provided to the public by the defendants. And if that information was false, the issue for the court is whether the defendants knew or should have known they were presenting false information, and whether the defendants had a duty to disclose true information that they had breached. And again, the public or the plaintiffs are seeking public evidentiary review and evaluation, and the defendants oppose public evidentiary review and evaluation. So far, two courts have denied plaintiffs' requests for preliminary public evidentiary review. In the second case, that denial happened in August 2025. The second case was the one where the petitioners, who have not filed a complaint yet, wanted to do a preliminary evidence proceeding, and the court said, no, I'm not going to authorize that. That happened in August 2025. In the main case, the court denied the plaintiff's request for a preliminary evidence hearing. I think that's what it was called, or a pretrial evidence. I'm not sure what the request was for or what it was named, but it was asking for a preliminary evidentiary proceeding. In September 2025, the petitioners, whose request had been denied in August, appealed the denial. This was the second case. The case went to, eventually, the Amsterdam Court of Appeal, and the Amsterdam Court of Appeal scheduled a hearing for March 9th, 2 weeks from now, to hear argument on whether or not the appeal should be allowed to proceed to a decision. And the decision at that point would be, did the Leeuwarden District Court err in denying the request for provisional evidence proceedings? The reason why it's going to this oral hearing is because there's an article in the Dutch Code of Civil Procedure called Article 200 that has a section barring appeal of preparatory evidence decisions unless the court determines otherwise. So reading from that section, quote, a decision on the application for one or more preparatory evidence events is not subject to any higher remedy except where the court decides otherwise. In such event, the time limit for initiating the higher remedy is 4 weeks. The petitioners got their request or their appeal in within the 4 weeks, and they are asking the Amsterdam Court of Appeal to determine otherwise, to allow the appeal to proceed. And the way they put it in the terms of Dutch law is to break the ban on appeal. The case that both sides are citing to is called Enke versus DuPont. It was a 1985 Supreme Court of the Netherlands case that put forward 3 possible situations in which the bar on remedies can be broken through. One of them is if the lower court has stepped outside the scope of the relevant provision. The second one is if the lower court has wrongly left the provision unapplied. And the third one is if the lower court, in handling the case, has disregarded such fundamental principle of law that the case cannot be said to have been dealt with fairly and impartially. The petitioners are arguing that provision 3 is the one that applies, that the fundamental principles of law pertaining to fair and impartial trials were disregarded by the lower court. They go through the different things that the lower court said and did not address in the lower court's decision, that August 2025 decision. And they also cite the European Convention on Human Rights, Article 6, which is a right to a fair trial. Similar grounds in the United States for appeal would be things like legal errors, abuse of discretion, constitutional violations, factual errors, procedural irregularities, and manifest injustice. And so at this March 9th hearing, and in the papers that they filed beforehand, the defendants have said they oppose the, the Court of Appeal hearing the appeal at all. The defendants argue, that the lower court decision and the lower court procedures were conducted fairly and impartially, so there's no reason for the Amsterdam Court of Appeal to break the ban on appeal. Now we're at the last section, which is section 9 about case documents and supporting material. So I'm going to go through the last one or two slides and then pause the recording, switch over to my web page, and scroll through that to show people what's available there. But this is about what's available at the Leeuwarden litigation page at Bailiwick News Archives on WordPress. The link is here if you're interested. At the top, there are links to the Recht Oprecht website, which is the foundation that is supporting the two lawsuits, and the website or the YouTube video page for that foundation. There are links to the St. Benedict memo. There's a link to a short document that was my responses to questions that were sent to me by Michael Neverdakis at Children's Health Defense about these cases. There's a 10-page memo that I wrote in support of the petitioner's appeal. And there's a copy of that organizational diagram showing the headshots of the defendants. There's a link to this presentation video. There's a reading guide, which includes that organizational diagram, plus biographies of the defendants, plus a table about acronyms used in the case documents and some of the laws that are cited. And then I have two sections where I've uploaded the case documents for the main case and the second case. So you can click on any one of those links and go and read the English translation of the filing that the plaintiffs or the defendants or the judges put into the case, those cases. There's also a section on press releases and press conference transcripts. There's a section on memos and affidavits and video statement transcripts by the nominated witnesses. And if you are going to go and start reading some of these documents, I recommend that you start with the July 2023 plaintiff's complaint and then read the January 2024 answer that was filed by the State of the Netherlands and the other government defendants. So here is the web page. The URL is bailiwicknewsarchives.wordpress.com/litigation Leeuwarden, Netherlands. I last updated it today, February 23rd. And I'm just going to scroll through what's here. If you want to go to the Right to Justice Foundation website, you would click there. They have a YouTube channel also. Then I have some of the work that I have written either about the cases or for the cases. St. Benedict memo, a transcript of my video statement, my response to the Children's Health Defense questions, a memo that I wrote in support of the petitioner's appeal. This memo was submitted to Peter Stassen, the attorney for the petitioners. It is not being submitted to the courts, either the one at Leeuwarden or the one at Amsterdam. Then there's a case document reading guide. It's about 35 pages. It has biographies about the defendants. It has acronyms and a few other things. Then there's a couple placeholders for this video presentation and for the slide deck. Then I have a little section about recent case activity. Most of this is about the appeal hearing that's going to be held on March 9th. Then I have that diagram. And here are the case documents. So it starts with the main case, the first thing that was filed. It goes through the answers filed by the defendants, goes through the plaintiff's increase of claim and request for pretrial hearing. Goes through the plaintiff's conclusion of reply, the final answers by the defendants, and the verdict, which basically said we're going to schedule some more things to happen next year, meaning 2026, granting the increase of claim. So granting that request that the plaintiffs made to say it's not just that the defendants did these things in 2020 and 2021, they are still saying the same stuff. So they need to be held liable for all of their acts up to and including what they have done by the time there's a decision in the case. And then there is a letter that the plaintiffs sent to the lay warden court submitting video statements and reports. And then for the second case, it's the same thing. It's the things that the petitioners filed, the things that the defendants filed. And then it ends up with the letter from the Amsterdam Court of Appeal to the parties explaining the procedures for the March 9th hearing. Then there's a section of press releases, press conference transcripts, video statement transcripts, and an invitation for the press to attend a press conference that's going to be held after the Court of Appeal hearing on March 9th in Amsterdam. If you're looking for other things I have written or other interviews and presentations, those are also here at this website. There's my legal research and writing collected and the interviews and presentations that are available in video form.